All right, so hey, this is a series of the top 10 probate cases in the state of Florida in 2025. The first case we have up here is Patricia Mlan versus the guardian of Patricia Mlan. April 4, 2025, second DCA right here in Florida. Good judge down in Sarasota, Charles Williams. What happens is mom goes into a guardianship. Patricia Mlan is incapacitated, and so there's a guardianship established. Guardianship is a bad business. Don't ever get in one. I've got judges that have told me if you start to get incapacitated, you put something in the door. It says the guardianship's examining committee is not welcome here. But the reality is, it's a reality for lots of people in the state of Florida. You start using the marbles, start losing capacity, you go into guardianship. In this particular case, Mclean's in a guardianship. The ward is being taken care of by a guardian. Guardian submitting bills. All this stuff is supervised, I suppose. But there's lots of bills that flow through things, and I think there's a lot of, there's bills that are big, and there's lots of challenges to bills that should occur and be processed in a timely manner. I'm not sure that's always done, but that's a whole other subject. What happens here is after mom dies, the son, John Mlan, is appointed the personal representative of the estate of his mom. And he, at that moment, then files some challenges to the guardianship fees and the accounting of the guardian. And again, one of the things in these guardianship cases is fees just start piling on. You got fee on top of fee. You got trustee billing for this, guardian billing for that. You got attorneys. You got all this stuff going on. And in this particular case, the issue was the son in the PR files these objections. Say, hey, judge, we got a problem here. I want to look at some of these bills of the guardianship and challenge them. Judge says, no, you don't get the opportunity to do that. Well, second DCA reversed and said that the trial court deprived Mlan of his procedural due process rights and opportunity to be heard on the limited hearing of the standing instead of not allowing the actual substance of the things to be challenged. So guardianship allows for those fees to be challenged.